Um, Today's speaker is, I'm Catherine Grover. I'm with the Windsor Vermont Historical Association. And when we found out that Jeff Amestoy was writing on Clarence Darrow's involvement in a Windsor murder case, we heckled him until he came down here and spoke to us. Jeff is a former Attorney General for the state of Vermont and a former Chief Justice of the Supreme Court of Vermont. And the story he tells is that 50 years ago, he was in the attorney's room at the Windsor County Superior Court, and he saw a photograph of a trial, and he asked about it, and someone said, "Oh, that's the most sensational murder that's ever happened in Vermont." And since then, he's been working on it. So here's Jeff.
Well, first of all, thank you for being here on such a beautiful day. When Catherine told me the meeting was to be in the select board room, I said I'd been there before, but it turns out not in this room, but as a young lawyer in Windsor in 1973, I was often obligated to be at select board meetings. And on those occasions, when the weather was beautiful, I was committed to being at the meeting. I admit to wishing I was elsewhere. So to those of you who have the same wish today, you are in front of a sympathetic judge. I'm grateful to the Windsor Historical Society and to Catherine for today's invitation, and most of all for the assistance when I researched this book. I've made my acknowledgments in the introduction to the book, but I did want to again thank everyone. When I began my research by calling Catherine to ask if she knew anything about this case, to my surprise, she said a relative of Cecelia Gullivan has just been here. You know, the case was 99 years ago, so it was quite a surprise that we both arrived for research on the same week. She put me in touch with Christine Simonson and her cousin Jane, who are of great help. They had done their own research. Christine was related to her maternal grandmother was a cousin of the victim of this case, Cecelia Gullivan, and it was that prompted her interest in the case, of course. And for those of you, if you look at the book or have looked at the book, there's a wonderful picture of Cecelia Gullivan in the book when she was a 22-year-old bridesmaid for Christine Simonson's great-grandmother and her grandmother, and very grateful to have that photograph. As Catherine said, I did first come to any notice of this case as a young lawyer from Windsor in the Woodstock courthouse. And seems like I've been working on it 50 years, but I haven't really. I'll tell you a little bit about how I got started. But it was true that in that courthouse, there's a lawyer's room, and you're usually in the lawyer's room before you go into the courtroom. It was my very first appearance in court. So I was extremely nervous, and it was only to make conversation with the senior lawyers, all of whom in that room were senior to me, that I said, "What's that picture on the wall?" And then someone said, "That's the most famous murder trial ever to occur in Woodstock courthouse." But my interest really became much greater 2 years later. I spent a year practicing law in Windsor. I became an assistant attorney general. I was researching a case, and in the course of that research, came across the Vermont Supreme Court decision of State versus Winters. And for those of you who've ever looked at, if you've ever looked at a Vermont Supreme Court case report, they always list at the beginning the lawyers who represent, in a case of a criminal case, of course, they list who the prosecutors were, and then who the defense lawyers were. And to my great surprise, astonishment, really, when I looked at it. It said, representing John Winters, Clarence Darrow of Chicago. Well, I think more people in this room than probably generally will know who Clarence Darrow was. It's really sort of generational, and when we proposed a title for the book, I had the murder case that brought Clarence Darrow to Vermont, but a number of folks advised me, including my daughters, that they didn't know who Clarence Darrow was. So we altered that to the most famous lawyer in America, which he certainly was. But just again, in terms of the extraordinary celebrity he was in the 20s, and I think it's important to remember that the 1920s here, which I think in some ways mirror our times right now, you had extraordinary interest in celebrities, right? Because you hit a point where radio is now a huge deal. Newspapers were in a circulation war, and murder sold newspapers. And so there was just tremendous coverage of murders anyway. And then, of course, of celebrity, Lindbergh and Chaplin, Babe Ruth. And Darrow was as famous, as well known as any of them. I mean, he was just an extraordinary celebrity, famous for speaking out against the death penalty, and really an icon in the sense that his name came into the culture. Somebody was saying, well, you really must have studied Darrow in law school. I said, no, it wasn't so much that. It was just Darrow. I said, it's like, when people say, you need an Einstein to figure out this problem. People would say, you need a Darrow to get you off if you're charged with a crime. And if you go back and see Dragnet, I'll bet you there's 6 episodes where somebody says only Clarence Darrow could get you off. That's how well known he was. I asked a friend to review an early draft of Winter's Time, and when I asked his opinion of it, he said, there's a lot in it, which is sort of a neutral statement, I thought. But he was right in that the book really divides into 2 parts. The first part covers the murder of Cecelia Gullivan in the trial of John Winters. And the second part covers Clarence Darrow's arrival in the case. He was not in the trial of the case. He arrived to argue the case after the conviction before the Vermont Supreme Court. It does seem like there's a lot in the book, and it certainly seemed, having spent a fair amount of time writing it, I thought it would be a lengthy book, but I was surprised. You'll be happy to know the book is probably only 100 pages long. And so I think I've learned as a writer that sometimes less is more. And the good news is I think that's also true of a speaker. So today I'm going to give you a synopsis of sort of the first half of the book. That is the first half, which covers, as I said, the murder and the trial. And then the second half, hope to leave you hanging a little bit on the second half, which is when Clarence Darrow arrives, and then if that interests you, you can find the second half in the book. But as Catherine was saying, it really was 50 years, and almost actually more than 50 years ago when I first thought of this making a good story. I took a detour, as she suggested, 12 years as Attorney General, 8 years as Chief Justice. I don't claim that makes Winter's Time a good book, but it certainly gave me a perspective on the challenges confronted by the prosecutors and then by the Vermont Supreme Court, which had an extraordinary time in dealing with, a difficult time in dealing with this case. So it gave me a perspective on both the challenges of the prosecutor, the Attorney General, and certainly the Chief Justice, who really had some challenges. I really began, though, working on the book probably 3 years ago, and I began by going to the Vermont State Archives, and I remember saying to the archivist there, do you have records from the Windsor Superior Court? And she said, yes, we do. And I said, well, I'm looking for something on a noteworthy murder case, State versus Winters. She said, would you like to see the transcript? I said, you have the transcript of the trial? And she said, yes, we do. And sure enough, in 3 volumes, there was the transcript, 1,000 pages long, typed by a court reporter in those days, not a single mistake in the entire one. But it was that transcript that then gave me the opportunity to really write the book. Without it, I never could have. And it also gave me part of the subtitle for this book, because much to my astonishment, when I read the transcript, it is there that I found out that in the course of this trial, there was introduced into evidence the severed head of the victim. Something that I'll speak to a little bit later. But I began the first part of the book talking about Cecelia's day. And it was an attempt first to reconstruct the day she was murdered, November 6th, 1926. But I also meant by that Cecelia's day in terms of the 1920s, of Cecelia being in Windsor, Vermont. As all of you here, as obviously by your attendance, are interested in history, you're familiar with the challenges of reconstructing history, and particularly reconstructing history even when you have a tremendous amount of material. That wasn't the case in terms of what I had about Cecelia Gullivan. There really was not a lot about her that I was able to find. But I don't think I missed the mark when I concluded that she was a remarkable woman for any time. And she was certainly a remarkable woman for 1920s in Windsor, Vermont. She held what was probably the most senior executive position of any woman in Vermont in 1926. She held it in a male-dominated world, in a male-dominated industry. She was the treasurer of the Cone Automatic Machine Company. But beyond that, she was a machine tool expert in her own right, in what was literally a revolutionary industry, as you know, in the United States at the time. Many people have compared it to Precision Valley and Windsor, Vermont, and Springfield and the machine tool industry to the Silicon Valley in terms of the significance of each to the American prosperity. And I think that's a legitimate comparison. And the comparison is apt in another way. It was extraordinarily rare for a woman to have a leadership position in Silicon Valley in the early days of Silicon Valley. And it certainly was just as rare for a woman to have a leadership position in Precision Valley in the 1920s. In 1926, Cecelia Gullivan was at the center of, in terms of responsibilities, and in terms of really, when you think about the state of the American economy then, and Windsor's significance in it, at the center of an extraordinary period, right? Calvin Coolidge was President of the United States. They called that period of time Coolidge prosperity. He'd been elected on his own right in 1924. By 1926, it was clear that if he wanted to run again, of course he did not, but if he had, he would have been elected. Hoover was elected on Coolidge prosperity. Many people thought that there could be no downturn, that we had finally figured out economically how to get rid of hard times. So that's the perception of the economic situation at the time. Cecelia Gullivan and Frank Cone were at the center of that prosperity. For many Windsor women, and certainly for some men, Cecelia Gullivan was the modern woman. She was stylish. Her boyish haircut, her 20s styles complemented her slender figure. She drove her own car. She owned her own home. She was a successful 43-year-old single woman. who on the evening of November 6, 1926, took special care with how she looked. She was meeting her boss, Frank Cohn, who was returning from a business trip to Detroit, where he often was, helping the automobile industry with the machine tools developed by Frank Cohn. So that evening, they met together at about 10 o'clock at night. The next morning, she was dead. Her body was not discovered until November 8th, when Frank Cohn went to her home, because the usual punctual Gullivan had not appeared at work Monday morning. When Cohn found Cecelia's dead body on the sleeping porch of her house, he returned to Windsor downtown, went to Dr. Martin, who was her physician. They then went to the police. They returned to Gullivan's home, and there they went onto the sleeping porch where the body was under sheets and blankets. Dr. Martin lifted the sheet covering the body, asked at trial if he had replaced the sheet. Dr. Martin said, "No, I dropped the thing. I was so horrified." But it was not until later that day, that Monday afternoon, that Windsor residents really learned about the murder of Cecelia Gullivan. It was actually another crime that had occurred at 2 a.m. Sunday morning, that same night, that Windsor residents were talking about. And that was a break-in at the house of Margaret Toddy Everts, where at about 2 o'clock in the morning, an intruder had broken into the home and had stood over the bed of Toddy Everts, who was at that time an invalid, about 34 years old, who had nursing care. The nurse actually had a bed almost adjacent to her. The noise awoke the nurse, who got up and then tried to grapple with the intruder. The intruder beat the nurse badly and then ran off when neighbors could hear the scuffle and breaking glass. Bessie Pangiris, who was the nurse, was unable, of course, that evening to speak to anyone about identifying who might have assaulted her. But later that Sunday afternoon, she was able to speak both to investigators and to reporters. And at that time, she said, I can't identify who it was. I know he was drinking.
I know he was drinking?
I know he was drinking. The Vermont Tribune headlined, "Murderous attacks on two women stir Windsor to a high pitch." It characterized Cecelia Gullivan's murder as the most brutal murder in the history of Vermont. It was not only the brutality of the murder and the prominence of Cecelia Gullivan, but also the break-in into an Everts house that magnified this into a national story, really. As you know, the prominence of William Maxwell Everts to both Windsor and to American history is significant. The Everts family still had, certainly in 1920s, a significant part of both the social and economic pieces of Windsor. So that expanded expanded news coverage, which certainly in the Northeast was really significant. There was, as there always is in a notorious case, a demand for information and for action. What did the police know? Were there any witnesses? Had they found a murder weapon? Why the break-in? Why the assault? Why was Gullivan murdered? The police did not know, nor did the Windsor County Sheriff, although he claimed he did. The Windsor County State's Attorney had no clue. And the Vermont State Police would not be, there was no Vermont State Police in 1926, 1927. It was another 20 years before Vermont State Police was established. But the Vermont Attorney General knew what every Attorney General knows, including this one. In a notorious criminal case, you need the best prosecutor, and that seldom is the Attorney General. Vermont Attorney General J. Ward Carver had just been elected to his first full term of office 1 week before the murder. Now he was responsible for finding and convicting a yet unknown murderer. The Attorney General went directly to Governor Billings and asked for the appointment of a special prosecutor. Billings, the governor, was as interested in the Attorney General in making sure that the perpetrator was brought to justice. They agreed that Windsor River Junction attorney Raymond Traynor, considered by many to be Vermont's best trial lawyer, should be the special prosecutor. And as the trial would demonstrate, he was an inspired choice. But as Clarence Darrow would argue before the Vermont Supreme Court, Traynor was a prosecutor who was determined to obtain a conviction irrespective of the fairness of the trial. The first thing that Traynor and the police needed was a suspect. The Windsor police, and particularly the Windsor County Sheriff, Wallace Fairbanks, thought they knew where they could find one. The Vermont Tribune put the investigative approach more directly than prosecutors would have preferred, and I quote, "Windsor Village has the Vermont State Prison. Every day sees the release of prisoners. Some of these men are of the lowest type. Those in charge of the preliminary investigation thought here was the solution to the mystery of the murder." It was not clear why John Winters was initially targeted by investigators, beyond the fact that he had served time for sexual assault, had done work for the Everetts, and and was an employee of Cone Automatic. He'd been released from prison in 1990, and in the subsequent 7 years had lived in Windsor, had raised a family, had not gotten in any other trouble that had resulted in any kind of arrest or conviction. But he was taken by the authorities to the state prison, placed in the death cell, and held there for 5 days. He was not arrested, and when he was confined, he was entitled neither to remain silent nor to a lawyer. The so-called Miranda warnings, which you're probably all familiar with, that where a person in custody must be advised of the right to remain silent and the right to an attorney, was not constitutional law until 1966, 40 years later. In fact, the Vermont Supreme Court had just issued a case 3 years before in which it admitted into evidence a confession of a defendant who was chained to the cell floor and was in solitary confinement. Sheriff Fairbanks, who, if there are any readers of the book will know, had his own reason to divert the public's attention from his own criminal problems, told reporters that Winters would soon confess, quote, because he would not be able to stand up under the cruel grilling of State Detective Brown. Brown was the Attorney General's investigator, and he did try a number of good cop, bad cop techniques to see if it could induce Winters to confess. Most noteworthy, what he did was he brought Winters to the home of Toddy Everetts, and then had Winters stand over the invalid's bed, and then had Bessie Panjur stand in back, and sort of recreated the events of that night. That was the equivalent of, in the old days, of the lineup, except here there was a lineup of one. When Detective Brown told Winters that the nurse had identified him as the intruder who broke into the Everett's house, Winters didn't believe him. So the detective then had the nurse repeat the identification in front of Winters. Winters said, "Then take me out and hang me." But he still did not admit to anything. And he did not admit anything to Detective Brown. On the 5th day of Winters' confinement in the death cell, Detective Brown asked the special prosecutor to come to the prison to see if they could get some kind of a confession. But they could not. They did get a statement, but it was far short of a confession. The prison warden had described Winters as a tough nut. He was either that, or worse, he was not the murderer. The state either had to release Winters or arrest him. They chose the latter on Saturday, November 13th, 1926. John Winters was charged with breaking and entering into the Everett's house, the assault of the nurse, and the murder of Cecelia Gullivan. Sheriff Fairbanks described the case as iron-bound from the beginning. Special prosecutor Traynor knew better, and so did Springfield lawyer Herbert Tupper, who was assigned by the court to represent Winters. Tupper was not Clarence Darrow, but he was a good enough lawyer to earn Darrow's admiration when they worked together on the appeal to the Vermont Supreme Court. Tupper went to Windsor State Prison to interview Winters for several hours. Winters was to be arraigned the next day. Prosecutors expect Winters would plead not guilty to each of the 3 counts. Many other people, Windsor residents, readers of the Boston Globe, Sheriff Fairbanks, and others were led to believe that Winters' lawyer would have his client plead guilty to all 3 counts. Herbert Tupper's lawyer had a different plan. He said to the prosecutor, if John Winters has been arrested for murder, on what evidence has the arrest been made? It was a good question, and the special prosecutor knew he could not answer it. Readers of Winters' time, if there are any here, will know the extraordinary lengths the prosecutor had to go through in order to get a point where there was actually enough evidence to indict John Winters. There were several preliminary hearings. There was no place in Windsor large enough for the crowds that attended them, so they had them at the Windsor Armory, literally on the basketball court. Those lasted, they had two of those hearings. Really what the prosecutor was doing was stalling until he could convene a grand jury. In a grand jury, you're not entitled to, the defendant's not entitled to have his lawyer in a grand jury. And grand juries are seldom used in Vermont. I was Attorney General for 12 years. We never used a grand jury to indict. And so it was rare. There had been one in Windsor 5 or 6 years before, but again, fairly extraordinary. The old saying is a grand jury would indict a ham sandwich, and there's some truth to, you have to be a pretty poor lawyer not to be able to obtain an indictment before a grand jury when the defendant's not represented by counsel. The indictment came down in, the grand jury indicted in December of 1927. Winters pled not guilty to that indictment. The trial then began on January 19th, 1927, lasted almost a month until February 18th. It was a remarkable trial in many respects, and at least as a lawyer, looking at Traynor's, Special Prosecutor Traynor's trial strategy, it demonstrated that he deserved the reputation as really one of the great trial lawyers in Vermont. It was essential to his case that he persuade the judge that he wanted to introduce evidence of the assault at the Everett's house. And under the general rules of evidence, it's ordinarily not permissible to introduce evidence of another crime in the trial for the crime charged. So even assuming that Winters was the Everett's house who was the intruder who broke into the Everett's house and assaulted the nurse, that evidence would ordinarily not be admitted. But there's an exception to that rule if you can demonstrate that the defendant had a plan, it was part of a plan and part of a motive, crimes were linked somehow that way, then the evidence can be introduced. Traynor was successful in persuading the trial judge that what linked the 2 crimes was that Winters had as a motive a sexual assault of the woman in the Everett's house and of Cecelia Gullivan. On appeal, Clarence Darrow argued that it was reversible error for the judge to allow the jury to hear the Everett's evidence, saying it was dangerous evidence. No jury could fail to be affected by it. Nothing could be more calculated to affect one. But the judge did allow the evidence, and actually on this point, the Vermont Supreme Court upheld that. The significance of admitting that testimony, of course, was now you had an identification of Winters, because the nurse could say positively that, at least she swore under oath, that Winters was who had assaulted her. And then you had other evidence that linked Winters to the murder of Cecelia Gullivan, but it was still an entirely circumstantial case. One piece of evidence that clearly had an effect on the jury, and actually I got to think more about this just the other day. Trousers that they had taken from Windsor's house that they claimed he had worn that night had burrs on them. Burrs were found on the nightgown of the nurse who had been assaulted, and burrs were found in the bed of Cecelia Gullivan. I was out trying to do some yard work 2 days ago. I came back into the house. Pants were covered with burrs, and I thought, yeah, Vermonters are going to know that that's something that would be you wouldn't be looking to clean that up if you were engaged in a crime. So I think that kind of a circumstantial evidence had impact, and of course he could only introduce it. The prosecutor it only made sense if you started with burrs on the trousers, then in the Everett's house, and then in Cecelia Gullivan's house. But even with the Everett's evidence, it is clear that the prosecutor did not believe he could convict John Winters without more. The more was Exhibit 35, the severed head of Cecelia Gullivan. It had been removed by the medical examiner because the special prosecutor needed to demonstrate the state's theory of the instruments that the state claimed were used to murder Cecelia Gullivan. Gentlemen of the jury, said the prosecutor in his opening statement. Women were not allowed to serve on Vermont's jury until 1943. Gentlemen of the jury, the state will show you the weapons that could have made the wounds. I was very struck by that word when I read his opening statement. Investigators had seized from Winters' home 1 week after the arrest a chisel and an automobile spring. Trainer intended to demonstrate how the wounds were made with a demonstration unprecedented in Vermont criminal trial history, and as far as I could tell, in American trial history. He did so by calling Dr. Fred Kent, the state's medical examiner. Trainer began with this question. At the time you performed the autopsy on Miss Gullivan, did you take some part of her body away with you, Dr. Kent? Yes, sir. Question, what did you take? Answer, I took the head. Question, and have you Miss Gullivan's head? Answer, I have. Have you it here in court, ready to produce? Answer, yes. I was shocked, even as a prosecutor, reading a cold transcript 100 years after the crime. You can imagine the shock of those who were there. And there was something almost as shocking, at least to a lawyer, on the next page of the transcript. The judge asked the defense, is there any objection by the defense to the introduction of the head as an exhibit? And the defense lawyers responded, no objection. The failure to object is virtually inexplicable. That evidence certainly would have compelled the Vermont Supreme Court to reverse the conviction. But by failing to object, under the rules of evidence at that point in time. The issue was not preserved for appeal, which means they could never argue on appeal about the prejudicial effect of the head as an exhibit. And in fact, when you read the case report of State versus Winter in the Supreme Court, of which there were seven issues argued, and long recitation of facts, there's nothing about the severed head, because the issue was not preserved for appeal, and it was not reported anyway. So, although the trial lasted for several days after the introduction of Exhibit 35, and after the introduction, that the trial included Raymond Trainor's devastating cross-examination of John Winters, who had taken the stand in his own defense. But there's no doubt, to me at least, that once that Exhibit 35 was introduced, presumption of innocence was something that was going to be hard to presume for a jury, and so too was the chance that a jury would be listening to a court's legalistic instruction on reasonable doubt. The case went to the jury on February 19th, 1927. The jury deliberated 2 hours and found John Winters guilty of the first-degree murder of Cecelia Gullivan. Judge Frank Thompson had one question of lawyer Herbert Tucker. Do you expect to take this case to the Vermont Supreme Court? Turner's reply was brief and to the point, yes, Your Honor. 3 months later, in May 1927, America's most famous lawyer, Clarence Darrow, was speaking at Dartmouth College. 1 month earlier, on his 70th birthday, Darrow had announced his retirement as a practicing lawyer. It was huge national news. New York Times reported that Darrow intended to lecture and write. Dartmouth was a good choice to begin his lecture talk. Darrow's son, Paul, was a 1904 graduate of Dartmouth. And Darrow's topic, Why I Oppose Capital Punishment, was a lifelong interest of his. Some said an obsession. Darrow had never lost a client to the death penalty. When Darrow finished his lecture, a student came up to him and told him that there was a woman there with a letter for him, and told Darrow what it was about. Clarence Darrow, in writing his son Paul the next day, wrote, I told the boy he was crazy and no such thing could have happened. The letter the woman handed to Darrow had been written in 1904 by Paul Darrow, 3 days before his graduation. Paul's horse had been spooked, probably by a steam whistle, and had reared and had fatally struck and killed a 5-year-old boy. Paul Darrow, devastated by the accident, had given the boy's mother a letter with a pledge. If she or any member of her family ever needed legal help, Paul promised her that her father would give it. Now, 23 years after the accident, the pledge was being redeemed. I need your help, Mrs. Arthur Cooley said to America's most famous lawyer. My nephew, John Winters, is on death row in Vermont. And for what happens next, I've written a book. Happy to take any questions. There may be folks here that have.
What kind of a contribution did Fred Bicknell make? He was like a co-counsel.
He was co-counsel, yeah. It's a very good question, and there were 2 lawyers. Tupper was Herbert Tupper was originally assigned as the lawyer, and then when it became extraordinary that there was going to be, Traynor had called 50 witnesses to the grand jury, so it's clear that Tupper was going to need help. He had Fred Bicknell co-counsel the case with him. If you read the book, you'll find that I make judgments for what, I don't pretend they're accurate, but they're the judgments I made on my own experience for what they're worth of not only the prosecutor and the judges and the Chief Justice, but also of the defense lawyers. And I thought Tupper was had done a fantastic job as a defense lawyer in the trial. I thought that Bicknell actually had made some extraordinary mistakes. In fact, and again, this is only conjecture, the only explanation I could come up with as to why they let the head be introduced, it was because Bicknell, I think, thought he could demonstrate that that those instruments could not possibly have caused those wounds. But when you got into the trial itself, here you have Dr. Kent with literally the head on his knee, and then you have Bicknell on cross-examination trying to demonstrate that the chisel couldn't have fit the wound this way. And at one point in the trial, the judge says to Bicknell, "You're holding the chisel exactly the opposite of the way." So it was, and worse than that, then Bicknell asked a whole series of questions about the injuries and when she lost consciousness, all of which brought out details that made it very unlikely that the jury would ever pay any attention to it. So a long answer, but I made a rather harsh judgment of Bicknell. But I will say, and this is something I'm sure private lawyers would say, and of course, but Bicknell was the one that was made the judge. He eventually was made a judge.
That's when he left the case. Right?
Yeah, that's right, exactly right. And I think he was probably a good judge. But, John.
Having studied this case as thoroughly as you have, it's very impressive. But was Winter guilty?
I was hoping somebody would ask that because it gives me the chance to say, so readers are going to have to make up their own mind, okay? I certainly have an opinion, but
You're not going to share it?
I'm not going to share it, no. And
I have a follow-up.
Yeah.
Was the poor woman sexually assaulted? Did
No, the theory.
coroner's report show any such?
Well, there's interesting probably understates it. So, as an example of, I think, how good Traynor was as a prosecutor, and here there's some, I had to make some speculation, but it's not based in, not entirely my imagination. I had some sources for it a little bit. The relationship between Frank Cohn and Cecelia Gullivan had engendered some gossip. Part of that apparently was that they were having an affair, and part of that apparently was that she might have been pregnant. So that if you were a defense lawyer, defense lawyers, they always look for a Mr. X. Cohen certainly could fit that. So when Traynor put Dr. Kent on the stand, and literally after the excerpt that I just read you about the head, when everybody expected that he was now going to ask Dr. Kent about the head, instead he said, "Did not you made an examination of Cecelia Gullivan? Did you not? And beyond the wounds of the head, yes." And then he had Dr. Kent describe that, and the purpose of that was because Kent then said she had a tumor that made it impossible for her to have sexual relations, and that he had found that in the autopsy. So there, I thought that had the Traynor, by stressing that evidence that had done two things as a prosecutor. And one was he had removed from at least from those who had heard the gossip, any question that, that was related to some kind of pregnancy. And secondly, I think he laid subconsciously for the jury what might trigger a potential rapist's rage, and that and part of the theory of the prosecution's case was they had statements that Winters had made at work about him wanting to have sexual relations with Gullivan. So they built a case around that, and this was all part of that. But yeah.
Yeah, I just have three quickies.
Yeah.
Yes or no, we can.
Yeah.
Because I might have missed them
Yeah.
because I didn't hear. But they actually showed the severed head to the jury.
Yes.
That's, yeah, I guess I heard that right then.
Yeah.
Was this in fact Darrow's last case?
No, it didn't turn out to be Darrow's last case. And remember now, Darrow was not in the trial. He was at. Okay. He did the appeal, and actually, when you read, actually had to appeal before the Vermont Supreme Court twice in this case. He thought it was his last case, and the reason he thought it was his last case, he'd retired. He never lost a death penalty case. He wouldn't have done. I think he took this case because of the pledge his son made. He was close to his son, and because Winters was on death row. So that's why he took the case. But both he and his son had together built a business, actually in Colorado, a gas plant that had given them enough money. They had just sold it. That had given them enough money to live comfortably, both father and son. They had invested it in the stock market. In October, in October 1929, I have in the book Darrow wiring his son from London. I don't like the way the market looks. Make sure you get out now. But his son went the other way, bought more on margin. They each lost. They were completely wiped out. When Darrow died, his widow had to sell the furniture and the books. There's just nothing left. And between the time Darrow, so it was 1972, Darrow was 72 when he was arguing the Winters case. He died at age 80. That period of time in the 1930s, he was out trying to make money. So he had a number of, it's a long answer to your question, but he took a number of cases that I don't think he would ever have taken under other circumstances.
Last one, real quick. Was there an investigator involved by the name of something like Elmo or Almo Franzoni?
No, I know the name. I didn't run across his.
It might have been before his time.
I think it was before his time. Yeah.
You.
Yeah, thank you.
And thanks for the presentation.
Oh, thank you.
Great.
Catherine?
Was the head severed by the medical examiner?
Yes.
Yeah, I know, but was it for a medical reason, or was it at the behest of the prosecution?
Yeah, well, I think you have to, that's the right question. I mean, I think.
Why would you sever somebody's head from their body?
Yeah, I think it was done for that. I mean, I think the prosecutor, I think Traynor didn't think he could make the case otherwise. It was the medical examiner was actually a junior medical examiner. And I think my guess is Traynor spent an enormous amount of time prepping him, and in the book itself, I talk a little bit about some questions that suggest that. But I think that's right. There's when Darrow argues, of course, Darrow can't even touch the issue of the head in front of the Vermont Supreme Court. And Darrow's told when he argues in front of the Vermont Supreme Court, actually by Fred Bicknell, actually it's an accurate statement saying now when you're in front of the Vermont Supreme Court, you cannot argue facts. You have to argue the law. You can argue, this evidentiary question about motive and all the rest, but you can't argue facts. So Darrow reviews the transcript. He's not an appellate lawyer. Darrow is, the world's greatest trial lawyer, jury trial lawyer. But he gets in front of the Vermont Supreme Court. He's trying to argue points of law. But when he stands up, he basically says to the court, I was told I could not argue facts. The prosecutor here has just argued facts. If I were to argue facts, my first question would be, why did it take Bessie Pangeris 3 days to identify who the assailant was? And then you could just see from the way Darrow handled some of that, the difference that Darrow would have made in the trial. And Catherine's question is one I'm sure he would have raised right away. Right? Yeah.
It sounds like Darrow did not know about his son's
That-
accident.
Yes.
Darrow did not know about that.
That's
at
correct.
the time.
Yeah.
So
Complete.
that's interesting.
Yeah.
The post that he never told his father.
Yeah.
Like, I was in an accident that killed a child.
Yeah. So I try and and again, you're all readers of history and know, you try to draw from different pieces, some guesses. I thought in reading, there's a collection of Darrow's letters, which was as important to me as the transcript. And from that, you could draw the closeness that Darrow had to his son. I mean, although Darrow was, he had divorced his wife, he was not a family man, but I think he was always dedicated to his son. And the letter that he writes to his son the next day, when he says, I'm sorry, and he says, I'm sorry this has bothered you all these years. And of course, I'll do anything I can for her. She's offered some money, but I won't take it. I'll argue the case. I don't think there's much that can be done. We'll go to the governor if it's necessary. But I thought that was an indication of their relationship. But certainly, Darrow, there's the other piece I drew out of a letter. Darrow takes when Paul graduates, he takes Clarence Darrow takes Paul and some Dartmouth classmates on a trip to Colorado, sort of a graduation celebration. And after the trip, Clarence Darrow writes his wife, his then wife, and Paul's mother, saying, we really should do something to lift his spirits. He's so subdued for a graduation trip. And of course, he had no idea, nor did his mother, that this had happened. So there's more detail in the book, but it's a good question.
This is kind of a gruesome question, but
Yeah.
this was 3 months after the murder.
Pardon?
The head that they showed. This
Yep.
was 3 months, 4 months. I mean, how was it?
How was it preserved? Yeah. So this is.
That's gross.
Yeah.
I'm very curious.
Yes. So this is. Actually, I'm not claiming credit for this at all. I think Susan, my wife, would say he just gets a queasy stomach all the time. So I didn't spend a lot of time. I was able in the examination of the doctor, in trying to fit the instruments, the chisel to some of the wounds, there's some difficulty, and Traynor says to the doctor, of course the head would have shrunk some because it's preserved in formaldehyde, right? And so that's as close as I come. But I actually, I know that when Cecelia Gullivan's distant relatives came here, and I don't see them here. So.
They both got sick. They went on a trip to Ireland and came back sick.
Okay. That was one of the things that first they asked me, and I said, I don't know. And they said, well, we actually called the state examiner to see if where is it? I said, well, I'm sure it's not around, but but yeah,
You know to hide it.
yeah,
Would preserve it
yeah,
pretty much
yeah,
forever.
yeah, so, yeah,
Much of what happens in court is about being able to tell a story successfully.
Yeah.
Be a good storyteller,
yeah.
right?
Right.
So what's the difference between that and when you sat down to write your book?
That's a good question. Well, I think if I'd been a great trial lawyer, or a trial lawyer at all, my friends would say, the transition would have been easy, right? Because I think you're exactly right. Successful trial lawyers, Trainer was one, create the story, can tell the story. And I think that, so therefore, had my legal career been entirely as a trial lawyer, the transition might have been easier. But unfortunately, I was a Chief Justice writing long legal opinions. And the transition from writing legal opinions to writing a book is harder. But you know, test always is. Someone once said, the test is for the reader is it more painful to stop or more painful to go on? So, you know, I try to. I'd written another. I spent time at Harvard. I wrote a biography of Richard Henry Dana, much different topic, and much more involved in terms of. But even I remember sitting down with the editor there and saying, it's all about narrative tension. You've got to. And I think that's right. I mean, you've got to maintain the tension in the story that propels the reader to the next page. And one of the reasons that I only gave you part one of the book, because it's much easier to keep tension about the trial than it is about the Supreme Court argument. But that was a challenge in the second half of the book, and so I'm very interested in anybody's response to that, because to build tension into the appellate argument before the Supreme Court was more challenging. But I have to say, there are some extraordinary things that happened that made it easier. And then because I could identify, I think, I mean, I could identify, but I think the fact that I could identify with the Chief Justice and his challenges, you know, made me speak more to some of the non-legal things, intentions there. So I think all of those. But I'm sure there are a number of writers here in this audience, and you know, some days this is the best analogy I ever read, or simile, was it's like building a stone wall, right? You know, some days you get all the rocks there, and some days the rocks fit, and some days you're out there and the rocks are not going to fit. But you got to go out every single day and try to fit those rocks, you know. So.
So how did they determine the date of the death? If it sounds to me like the 7th of November.
Yeah, I mean, it was just however they, I mean, I think they made up, as they do in autopsies, I think they made an estimate of the time she died. They figured out, I mean, that she was assaulted. She died someplace between 3 or 2 o'clock and 4 o'clock in the morning. So I think, you know, then that's
Between 2 and 4?
a.m.
So it was a totally different time than the Everett's attack?
Well, the Everett's attack was at 2 a.m. They were trying to piece together both of those. I mean, the theory of the prosecution was that they were both linked. You know, they had a time frame probably there of 3 or 4 hours. So they made the point that all the homes are in proximity to each other. And
the Everett's is like the Stoughton house and the Everett's house.
Yeah.
That's not close to the Clough.
It's across, the burglary was across the street.
yeah, it was a number.
The back of the house was up against the railroad tracks.
Yeah.
It's not the Everett's house as we think of. It's a,
Okay.
But you're right. It's still quite a ways away. He had a vehicle as well, though. So Again, like Catherine's question, I mean, there's some holes that one can think of in terms of the prosecution's narrative here, but once they got that head in there, I don't think people were interested in listening to those.
Anybody else?
Yeah.
Quick question. It's not really, it's more about you rather than the book. I'm an engineer, a retired engineer, and involved in some safety instances, investigations.
Yep.
And the whole focus there is to find out what happened, make sure it doesn't happen again.
Yep.
So as a prosecutor, if you feel that somebody is actually innocent or guilty, how does it impact your performance all the time?
Could you just repeat the last question, part of it again?
As a prosecutor.
Yep.
And you're being given a case.
Yep.
And you think this person's definitely guilty.
Yep.
Or this person's definitely innocent. How does that affect your performance as a prosecutor? Or can you say, I won't take this case? Or do you have a choice not to take it?
Yeah, you would never, I mean, I can't speak to all prosecutors, obviously, but I can certainly speak to the Vermont Attorney General's office, I think, when I was there, and now and before. You would never bring in a prosecution of a criminal case, you would never bring a criminal case unless you were persuaded that the evidence could show beyond a reasonable doubt the guilt of the defendant. And in an investigation of cases, you end up making a determination that the harder part is when you believe the defendant is guilty, but you just don't have enough evidence to go forward, and you can't. So you can only, I mean, you're duty bound to prosecute only those cases in which you can say to yourself, say to those you work with, there's enough evidence here to prove a case beyond a reasonable doubt. Now, of course, we've all been in cases in which the jury disagrees, and sometimes they might be right about the standard of proof, but I never had a case where I felt we were wrongly pursuing somebody. I had some cases where I thought the result was wrong, but I always respected. The juries. There is truth to the juries. They seem to find the right answer, and if they understand that you don't have enough, the beyond a reasonable doubt means something, and they could say you've proved it, but not beyond a reasonable doubt. But you just don't face the dilemma of saying now I'm prosecuting innocent people. But of course, that's not. It's not to say it never happens. And of course, it's one of the reasons that Darrow was so opposed to capital punishment, not just on the moral cases, because sometimes they got the wrong person. And and before, when you can imagine in the 1920s, just to use, I mean, if you use Vermont as an example, but you think of many other places in the country, no right in a custodial situation to a lawyer or to remain silent. A lot of cases were made that way. In those cases, there's no question that innocent people were convicted, but fortunately, it's not a problem I've ever had to face. Hi.
I read the book yesterday. I've never read a book in one day. That's how interested it is. And I tell you, I went through the whole thing and couldn't put it down. So
Well, that's,
thank you very much for bringing it.
well, thank you. That's great.
Thank you, Jeff.
All right.